Cross-Examination, a podcast by your host, the nationally renowned criminal defense attorney, Neil Rockheim.
Hey everyone, it's Neil Rockheim, your host of Killer Cross-Examination. And I want to talk today about clients that handicap their lawyer. I'm not talking about a client that walks in and takes a baton and smacks the lawyer in the ankle or the knee, or a client that, as your lawyer's walking down the hallway, runs up behind him and knocks him over and causes him to be injured, but something maybe not that literal, but figuratively pretty close. The client who lies to the lawyer. It happens all the time. I still don't get it. I've been doing this since 1993. And time again, I still experience, I hear from my peers, my associates in my firm, I hear from lawyers in other firms about clients that continue to lie to them about the facts of the case. What are you doing? It's like 22 karat idiocy to lie to your lawyer. You're lying to yourself if you lie to your lawyer. I mean, you ever heard the phrase, I'm sure you have, that a person who represents himself has a fool for a client and an idiot for a lawyer? I mean, they ought to modify that phrase for the client who decides that for whatever reason, it's in his or her best interest to lie to their lawyer. I can't tell you how many times it happens. You're figuratively handicapping us. You're sending me into battle with not only one arm tied behind my back, but also with one arm glued to my side and both my feet tied together, and making me do it in a knapsack or a potato sack. Making me hop around with one arm trying to punch somebody like this. I don't think that people realize, and I understand that they've got so much stress and so much anxiety, and I get that criminal cases can create that much anxiety, that much stress, that much pressure. I understand that. I get it. But man, oh man, I can't tell you, if you're listening to this and you are about to hire a lawyer, or if you have a lawyer, do yourself a favor. Tell your lawyer everything. Please. There's simply no point in you handicapping your lawyer. That's what today's episode of Killer Cross-Examination is all about. I have tried over the years to come up with speeches, different ways to explain it, different ways to say it over and over and over again, different ways to try to point out that you ought to tell me the truth. I tell them I'm not going to judge you. I'm not here to judge. I'm not here to pass judgment on you. I need to know everything. I'm the last person to lie to. If you lie to me, you're lying to yourself. Tell me everything. I then tell them stories in the past so they can relate, that they can hear about other clients of mine who've come in and who've told us 1/4 of the story, 1/2 the story, 70% of the story, 85% of the story, 95% of the story. And I try to explain to them how time and time again, that gets us into a jam. Doesn't end up hurting me, because guess what? I go home at the end of the day. I go home and I put my head down on my pillow, and I the next morning wake up and I tackle a new case. It ends up hurting you. It ends up hurting the client. But for whatever reason, people still do it. And I understand that the pressures, that the dynamics of being accused of a crime are that you so desperately want to try to convince your lawyer. You so desperately want to try to convince me, your lawyer, us, your legal team, that we ought to believe in you, that we ought to trust you, that we ought to support you. I get it. I understand it. But dribbling out the truth for us or doling it out in little bits of, in little, dollops or little cups or little thimbles full of truth is dangerous. You might as well juggle hand grenades. What's the point of turning to someone like me or turning to a lawyer in a criminal case or a lawyer in a civil case if you're not going to be straight with them? We lawyers can do a lot with the truth, with the whole story. When I hear everything and someone tells me, a client tells me what's going on or tells me the story, what I tend to do is I'm processing it. I'm processing it fast and quickly. And I'm thinking about believability, credibility. I'm thinking about how to present it. I'm thinking about the places that this can have an emotional impact on the listener. I'm thinking about how to repeat this as a story. I'm thinking about the strengths and the weaknesses. I'm thinking about how to tell this as a compelling human interest story. I'm thinking, how do I communicate this? How do I share this with others so that they won't view you, the client, as someone that's a criminal, but will instead have compassion, have empathy, have sympathy for you, so that they will actually understand the human, how it was that you ended up being accused or wrongly accused of this, how it was that this other person chose to come into court and lie about you, how it is that the police investigation was so deficient, or they were so quick to point the finger at the most obvious suspect, and that happened to be you, that you find yourself in the middle of this spider web and you don't deserve to be there. But I can only do that if you tell me everything. And no matter how bad the information is, I can deal with it. We can process it. We can attempt to, no matter how bad it is that you acted or what you said or how you acted with the police or what you did or didn't do, we can process that and attempt to understand it. At least be prepared for it, so we're not just caught like telling me to caught off guard. Not telling me, the lawyer, or not telling your lawyer a crucial piece of information is like sending me into a football game as a quarterback without telling me that they've got a absolutely amazing, terrific, don't throw to, put him on an island type cornerback, and just telling me, he's okay, he's fine, don't worry about him. Or telling me, don't, in a game in which, if I'm a golfer and there's a tremendous side wind, like I'm playing in Scotland, and I'm on the tee and the wind is blowing, 40 miles per hour from left to right. And I say, hey, how does that going to affect my shot? And you say, it won't. You're handicapping me. You're crippling me. You're not letting me prepare for what is out there. If I know that there's a 40-mile-an-hour crosswind, I can deal with it. I can try to hook the ball into the wind. I can play the ball to the left and let the wind carry the ball back into the fairway. I can process it and deal with it. If you tell me as a quarterback that the cornerback that I'm playing against is a guy that is going to lock down our receiver, I know that I'm not going to throw his way. Or we're going to come up with schemes in order to deal with that cornerback. I can give you analogy after analogy. But people still do it. And I understand. Not sitting here trying to pass judgment. I'm trying to encourage you, the person who's our client. I'm trying to encourage you. Or if you're going to be somebody else's client, to speak truthfully. Don't hide the most important, painful, difficult facts of the case. Don't hide the stuff that you're afraid is going to hurt your case. Because by hiding it, you're only going to make your case that much worse. And you're going to do something else. When you send a lawyer into battle on your behalf, whether it's to negotiate or to give an opening statement or to do voir dire or to argue a motion, what you do is you're sending somebody out that has credibility. You want your lawyer to have credibility with the judge, the prosecutor, or the jury. You need your lawyer to have credibility. Trials in legal cases are a constant battle, a seesaw of who has more credibility, the prosecutor or plaintiff's lawyer or the defense or defendant's lawyer. It's a battle. And when you lie to your lawyer and you impair our ability to go in there and deal with the worst facts, and you paint a rosy picture and it turns out that the picture ain't rosy at all, and you send us into battle, what you do is you undermine your lawyer's credibility. You pull the carpet out from under us. It's like tying my shoelaces together before I get up from the table. You do that. Don't stop. I can't tell you, like for example, in our office, we have become proficient in the use of polygraph examinations. You call them lie detectors, but they're polygraph examinations to assist our clients in their defense. In a wide variety of ways, we use polygraphs, and we have used polygraphs successfully. We've come to understand the science, we've come to understand the techniques, and we've come to work with some of the best polygraph examiners in the country. But we have clients, when we sit down and we talk to them about taking a polygraph, we share with them, we say, don't do it if you're gonna fail. Don't do it. Don't do us any favors. Don't spend your money on a polygraph examiner if you're not gonna pass. If you know you're not gonna pass, don't do it. Don't waste your money. You'd be better off taking your money out in the driveway and burning it or going to give it to a charity and at least feel good about it. Don't take your hard-earned money and pay a polygraph examiner knowing that you're going to fail. Don't do it. And people still do it. And then how do I know? Because they take the polygraph, assuring us that they will pass, that they should pass. Then not only do they not pass the polygraph, but then they confide in us afterwards or confide in the examiner. Yeah, they shouldn't have taken it. They did whatever they were accused of, whether it was something minor or something major or a major part of the case or just an issue for bond. But they end up admitting it. And for the life of us, we're looking at them, so we told you not to do it. You're not hurting my feelings. You're not going to hurt my feelings by not taking a polygraph examination. You look me in the eye, if I'm your lawyer and I say to you, you want to take a polygraph examination, and don't say yes if you're going to fail. You look me in the eye and you say, no, it's not for me. That's it. I'm done. I don't need I'm not going to press you to take a polygraph. And guess what? I'm not going to lose any respect for you, or it's not going to cause me to lose any of my zeal towards defending you. Quite the opposite. It may actually cause us to respect you more. We'll just respect the candor. You told us no, that's it. End of story. You don't want to take the polygraph? I don't push you as to why. It's fine. Don't take the polygraph. It's no problem. It's no sweat off my back. It's no sweat off my brow. And I appreciate you not putting yourself and us in that predicament where you took it and wasted money on it and failed. Just tell me straight out. But I think what happens is that people are so interested. They're so worried. They so want their lawyer to believe in them and to believe in their case and to fight for them that they think that if they agree to take a polygraph, even deep down inside, knowing that they're going to fail, that they think, you know what, I want my lawyer to believe in me. I want Neil to believe in me, so I'm going to agree to take it, even though I know I'm going to fail. You got to stop. We're in this business. We know how tough criminal defense is. We know what it's like because we defend people every day to watch people who are accused of crime. We understand the stress and the anxiety. You already have us as your lawyer. You don't have to worry. You already have Neil Rockhind as your lawyer. You don't have to worry about trying to impress me. I'm the last person you have to impress at this point. I'm in. If I agreed to take your case, I'm committed. I'm in. I want to win. I want to win for you. I want to win. You don't have to do anything like agree to take a polygraph to further, my desire to win. I'm going to want to win the moment that you agree to hire me as your lawyer. I want to kick ass for you. Whether you agree to take a polygraph or not. So don't feel like you have to, and I'm encouraging you out there, those of you that haven't hired a lawyer or have one, if there's information that you have been withholding from your lawyer, get it out there. You're not doing yourself any favor. In fact, you're doing yourself harm. You are disrupting and undermining our ability to negotiate a resolution for you. If I go out there and I think to myself that, my client is, I represent X, Y, and Z, and it turns out that X, Y, and Z is not true, but it's A, B, C, and I'm in there saying, yeah, X, Y, Z, X, Y, Z, X, Y, Z. And I'm banging the table, telling the prosecutor that there's no evidence of this, and there's no evidence of that, and don't you worry about that, and there's not, my client assures me that didn't happen. And then he pulls out like a recording and some text messages and some phone calls and some emails and a videotape or anything like that saying the opposite. You've undermined, you've just taken what my ability to negotiate for you, you've robbed me of my credibility to argue on your behalf, and you have pulled the rug out from underneath me. The negotiations are going to go backwards. Same thing with like discovery. I've had clients tell me, yeah, you got to get this piece of information. It's out there. Go get it. I assure you, there's no way that if you go get this blood test result or you go get this video, that it's going to prove that I didn't do it. And then we look at the client in the eye. You sure? You sure? You sure you want me to go get that? You positive? Yeah, I'm positive. You sure? Yeah, I'm sure. And we go out and we attempt to get it. We have our investigator get it. We go out and do a scene inspection. We go out and push hard to obtain disclosures. And sure enough, the thing that our client said wouldn't be there is there. Like in cross-examination. Undermine, can't tell you how many times clients have said to me, this is the case. I'm telling you, ask this police officer that. Ask the alleged victim this. Ask the complaining witness this. I'm telling you, and we're like, you sure? You sure I should ask that? Are you positive? You sure? And the client looks, oh yes, I'm sure, I'm positive, 100%. And then we pursue that on cross-examination and wham! It's like just getting socked right in the cheekbone. It's like just, getting sucker punched. We think we got this great bit of information that the client gave us and boom, just, jaw-breaking, face-rattling, surprise sucker punch. I don't know. I just see people doing it. They dribble out the information. They come in, they tell us a story. It sounds good. Then they leave the office, and then a few minutes later they call and say, I don't know if it's important to know. And then, of course, the piece of information they share on the phone contradicted something that they told us in the office. And we say, okay, fine. I appreciate that. Thank you. Anything else you want to tell us? No. And then a week later, hey, I was just thinking of something. Don't know if this is important. And of course, it's like, vital. It's like oxygen. It's, like the lifeblood. I just thought you should know. And you're like, okay, you didn't tell me that the last 2 times we talked, but okay, I appreciate you telling me now. Thank you. Thank you for that. Thank you for coming clean about that. Anything else I ought to know? Nope. Got it all. I've told you everything now. And then we get the police reports and the videos and we look at them and we're like, okay, can you explain? You said you were really cooperative and cool with the police, but I'm looking at a videotape now where you're basically motherfucking these guys left and right. Oh, I kind of forgot about that. Kind of. Was that important? And these are the sort of So the little bits of information we get, like more and more and more, like, little dollops of truth kind of given to us, like imagine if you're at the hospital and they give you like a little paper pill cup. It's got like 2 pills in it. We get like the truth delivered to us like that sometimes. A little cup at a time. We need the whole thing at once, man. These are some of the explanations I get. I didn't think it was important. I didn't think you'd want to know that. I didn't want you to not believe me or believe in me. I forgot. I didn't realize that they'd find that out. Yeah, that's a good one. You didn't realize that the state or the government, like the most powerful entities in our country, the entities that control law enforcement power and have investigative powers and that oversee and have the ability to do all these things, you didn't think they'd find that out? I wanted you to believe me. I wanted you to believe in me. So let me get this straight. I wanted you to believe me. I wanted you to believe in me, but I thought that I would lie to you to get you to do that. I wanted you to fight hard. You don't get it. I'm going to fight hard for you regardless. It's just a function of whether or not you're going to allow me or whether you're going to cripple me, whether you're going to prevent me from fighting well for you. If you want to lose your case, you don't need my help to do it. You can lose your case all on your own. You want to lie and you want to withhold information and you want to have a fantasy defense, you can do that without having a lawyer like me. If you want to have a real defense or you want to have a real case, you tell me what's going on. I wanted you to win. I didn't think it was important. I didn't think you'd want to know that. You're wrong. When I sat there and I told you that, tell me everything, it wasn't bullshit. It was genuine. I looked you in the eye like I am now and I said, tell me everything. I wasn't sitting there. It wasn't like a game, like tell me part of it. If I wanted to only get part of it, I would say, just tell me the stuff that I want to hear. Or just tell me the good stuff. Don't tell me any of the bad stuff you did. I can think of a case, like for example, we have clients who are out on bail and bond, and they have conditions, and their conditions are don't drink and don't use drugs. We look them in the eye, and we're like, hey, don't drink, don't use drugs. We make them sign something to acknowledge that we've told them that don't drink and don't use drugs. Like, you're going to be drug tested, you're going to be alcohol tested, don't do it. Okay, you got it? Yeah. And then I promise I'm not going to do it. And then we get believe it or not, we get some report back that says, client, we show positive on a urine test. Looks like Mr. Akin, like your client tested positive. Your client must have drank alcohol, or you tested positive on his or her, breath testing device. And I call the client. What the fuck? What's up? That didn't happen. Bullshit. No way. I didn't use. Okay? So we start running that shit down. We start ordering all the records. We start getting all the records from the testing agency. We start looking for errors, and we start looking for things that could cause a positive result. We start looking for potentially polygraph examinations. We look for other science that could undermine that. And then, of course, none of it pans out. Client goes and takes a polygraph and bombs it. Oh yeah, I guess I did use some alcohol. I forgot about that. All right. I didn't want you to disbelieve me. We're like, okay. The context of like a no contact. When we have witnesses, we have clients who are ordered not to have contact with certain witnesses. Like, hey, don't have contact with that person. Understand? Like, no contact. Don't text, don't call, don't look at, don't send smoke signals to, don't send an email through don't send a spoof email, don't send an anonymous email, just don't have any contact with him or her, okay? Yeah. Then we get some report that there's contact, and we go to the client. Oh, I didn't do that. I didn't have any contact. No contact at all. And then, we make a big deal out of it, and we go to litigate the bond issue, and prosecutor pulls out some proof of a phone call, a phone message. left by our client. Oh, well, I mean, she called me, so I just called her back. Like, we didn't qualify what type of contact you had, whether it was responsive or not. You said you didn't have any. That's the position that we staked out on your behalf. Now you're telling us that that's not true, or now it's proven to be not true. No, or we go to court and begin to litigate that issue, and sure enough, they produce like an email or a text message or a witness or a video. And then we got to take a break and look at our client and go, what the fuck? What? And in court, I got to have like a stone face. You know, I got to sit there when the bad shit's coming in that's completely different from what our client told us. I got to sit there and have like a stone face, cold face reaction, unflinching. In the meantime, inside, I want to fucking look over and go, what the fuck is wrong with you? Why did you not tell me that? Why don't you just take that pencil in your hand and stab it in my neck? But I got to sit there and just, stone face. And then say, Judge, can I have a break for a minute? Then go find a conference room and then close the door and go like, what the fuck? It's 24 karat idiocy if you lie to your lawyer. You're just committing harikari. You're just taking like the sword and you're just stabbing yourself with it, but you're stabbing us too. And we're here to help. Stop doing it. I can think of a example after example after example. I remember a trial where a client got up there in front of and swore left and right. This didn't happen. I could see the prosecutor sitting there. I'm like, he's way too calm about this. Way too calm. Just torpedoed her on cross. On a break, we're like, what was that about? You didn't tell us any of that. Oh, I didn't think it was really important. It's not really, but it's not about that. Okay, right. Gotcha. Perfect. Because you just totally, we had this trial one, we were like on the 2-yard line. I didn't even really need you to take the stand. You wanted to take the stand. We thought, okay, well, we were really close. We thought we're just going to punch the ball. We're going to punch it over the goal line with you testifying. And then basically all you did was just pick six yourself by not being truthful with me. I can prepare for all of that negative stuff, but I can't prepare and plan and have a contingency plan and account for what I don't know. If you lie to your lawyer, you're just lying to yourself. I don't know how many times, how many different ways I can say it. I can say it in Spanish. I can say it in Chinese. I can say it in Korean, Russian. I can say it in German, Hebrew. You name the language and I will say it. And it's going to be the same message over and over and over again. Tell your lawyer the truth. Don't hold back. All you're doing is handicapping and crippling your lawyer's ability to defend you. You're just hurting yourself. This is Neil Rockhind. I hope this has been a helpful edition of Killer Cross-Examination. I encourage you to subscribe to our podcast, like it, share it, particularly if you think there's some topic that you really want to hear covered. I'd love to hear from you and to hear the topic that you want me to cover in Killer Cross-Examination. This is about our effort to improve the criminal justice system and our clients' access to justice. Thanks for tuning in.